Here, the courtroom tension kicks in immediately. The defendant tries to clarify polygraph details, while the judge lays out the boundaries of privacy and public access. You can feel the suspense building as questions around evidence reliability surface, setting the stage for an intricate legal battle that will keep everyone on edge. Every statement here hints at conflict to come.
No contact order as of today, but it looks like it's already been done prior.
Okay. Right, I'm going to...
I have not had unlimited access. There's been one or two times I talked on the cell phone just a little bit, and I was supposed to talk again, and it didn't go through.
All right, well, I'm going to take a brief recess and review these other pending motions.
Hey, can you hear me, James?
Yes.
What?
Now, hang on. Keep in mind, everything that's said here right now is open to the internet and the public and everything else. This is not.
Yeah, I was just wanting to know.
James, Mr. Watt, James, did you hear me? This is not private. Okay, you understand that?
I just wanted to know about what had been set up on the polygraph test.
The polygraph examiner that most people use around here is an Augusta. I mean, I've had a chance to talk to Augusta. I frankly have no idea what he costs.
Well, I have money that's been on there. I haven't been using much money that's been on my account. So there's plenty of money out there.
James, James, polygraphs, and we touched on this before. Polygraphs are not generally admissible in court.
I can use them in other ways for filings and stuff like that to get them on the record. As in paperwork for filings and this and that. If I can't get it introduced in court, I'm questionable why it can't be introduced in when I've got people lying against me.
Because polygraphs are not reliable. They are not.
How come law enforcement uses them at times to establish whether there's probable cause or not?
Because law enforcement uses them as an investigative and interrogation technique, not as truth-telling, because they don't do that.
All right, we'll go back on the record. Same appearances as before. I now have before me a motion.
Now we hit the heart of the drama. The defendant demands full disclosure, sees firearms and ammunition, claiming he needs this information to defend himself. The back and forth over discovery highlights real stakes, missing lists, potential misunderstandings, and a high tension of being accused of theft of his own property. The courtroom energy here is at a palpable peak.
That I be given lists of all my firearms and ammunition seized from me, and a motion to reschedule the October 1 date of preliminary hearing. I want to address the motion regarding the firearm list at this time. Mr. Watts, I'll give you an opportunity to argue your motion. Go ahead.
Well, since I'm going to be, my parents are saying that evidently I took my own firearms and ammunition, I want to be able to question them on that and have know absolutely all the ammunition, everything that was in there by the brands, types and brands and stuff, and a list of all the firearms and everything. I should be entitled to that under discovery. I never was provided it.
Response, Ms. Pierce?
Judge, typically all that information is part of the KSO, KRO. I imagine that it is summarized or it is a part of that as well. I don't know whether he got full copies of discovery or not. I'm not familiar with exactly what it is that defense counsel provides to an individual who is representing themselves. So I don't know that he did or he didn't get copies of all of that, but that information should be a part of that arrest document. But then again, at the same time, I do not have a problem whatsoever providing him with a list.
All right. Yeah, typically I would assume that the seized property is included in the list. That's usually provided in discovery, so it sounds like a list does exist. I don't know what you've been provided, Mr. Watts.
I have not been provided that. It's been absent. Everything that was seized from anywhere, I have no record of anything. I know other stuff was seized, phones and different things, probably a computer at the house down there and different things. I don't have a list of anything that was seized anywhere. No list whatsoever.
All right. Attorney Watts, is that something that you could perhaps assist him in getting a copy of the list of seized firearms and ammunition?
Your Honor, I provided to Mr. Watts the copies of the discovery documents provided to me by the state with some redaction, and frankly, given that the victims here are his parents, who obviously has intimate familiarity with, not very many redactions. That was provided some months ago. The charge here, and the charge here is a burglary and robbery where the items that were taken were firearms. Those items taken are listed by the alleged victims. They're listed in the police report as a number of 6, 7, 8, 9, 10, 11, 12, looks like 12 firearms seized. It doesn't specify the particular firearms, or not, I shouldn't say seized, stolen. As to whether or not there is a list of firearms seized by law enforcement, I can double check and see if I can see that. I'll see if there is such a list.
Okay. Well, we don't need to go have everybody go through everything now, but to the extent that this list exists, I would ask that if there were firearms seized and if there's a list of those, that be provided to Defendant Watts.
Yeah, they were seized down at Leon when I had down Leon on me and in the truck. And then there was also the firearms down at the house. And they're accusing me of stealing my own firearms. So I need lists of those because there will be questions on those. And I also will try to go through arms list and get all the contact with people and my phones.
If the lists exist from law enforcement, then I'll order that those be provided. If in fact they do.
If I don't have access to a list, they shouldn't be allowed to say I stole it if I have no way to know what they're saying I stole.
Yeah.
I need to know the types of ammunition and how many rounds and stuff like that, so I know where the purchase was made.
All right, now we'll take up the motion to reschedule the October 1st preliminary hearing date.
The drama escalates as the defendant requests a continuance, arguing he needs time to gather evidence and verify claims. The state and judge push back, stressing 2 years of delays and prior hearings missed. This section is pure suspense. Will the defendant get the time he demands, or will the court hold firm? Every line underscores the balance between fairness and procedural urgency.
You've already made some comment to that regard, Mr. Watts, but go ahead if you have anything additional you'd like to say.
I'm going to have time to contact people and get all this stuff lined up. And I may have to write several letters to arms list and net 10 phones and stuff like that to try to locate information. And I'll have to probably have some way to send money for copies. So it's going to be fairly time consuming. I've also got my bank records that need to be dug out from my parents over the guardianship. They're saying I did tell her I needed those on that cell phone call that was real quick that I did get through to them, but I haven't been able to check up on that or talk to them anymore on their phone. But anyway, I need access to my bank records to show purchases. And she don't know how long it'll take her to dig those out. And I need those to evidence in court. Everything I can evidence in court, I need to get question and evidence so there won't be any perjury. I've had perjury to happen and put me in prison up there at Chase County. And it's not going to happen again. I don't know why there isn't liability for perjury in all proceedings.
All right, Ms. Pierce, state's response to continuance request.
Judge, this is a 2022 case. The first appearance on this came in on 4/18/22. So we are well past 2 years. Now, in the interim or during that time, there's been a competency evaluation. There's been a couple of care and treatments, those kinds of things. So that has delayed the whole process as well. I understand the idea that, you know, he has things that he wishes to have in his possession for his to present his defense. I think that the court and Mr. Defense Counsel, Mr. Watts, just did talk about being able to assist Mr. Defendant Watts in obtaining some subpoenas and documents and stuff of that nature. So I think that that can be done relatively shortly. I don't have any necessarily concern. The majority of the witnesses in this case, for the most part, they are the defendant's parents. We've not had a preliminary hearing of any sort. They are elderly. You always take a chance of something of their age when we deal with people of their age, of unfortunate things occurring. And I don't want to, in balancing the defendant, Mr. Watts' need for an ability to accurately present his defense against this whole ideal of continuing to delay this. I would just suggest to the court that if the court is going to grant the continuance, that the court would do it and make sure that we're not too awfully far out, and that there's an order that it not be continued again unless there's extreme circumstances, and that any delay that is caused by this particular request for continuance to be against the defendant.
All right, thank you, Ms.
And
Pierce.
I know that we're not at a speedy trial situation, and that we haven't had the preliminary hearing, or that we haven't done an arraignment. So I know that that doesn't necessarily apply. However, I want it documented that he is the one that asked for, the defendant is the one that asked for the continuance.
All right, thank you, Ms. Pierce. Going back through the docket notes, way back on September 20th of 2022, almost 2 years ago, we were set for evidentiary preliminary hearing. All the state's witnesses appeared. On that date, Defendant Watts refused to make himself available for the preliminary hearing. So then it ended up having to be moved, and then there were competency exams and so forth. This case needs to go to preliminary hearing. Mr. Watts, you've had 2 years to be getting all of this stuff together, and I'm not going to continue a date that we've had set now for several months for preliminary hearing at this time. If you wish to raise another request to continue the hearing when we come back on October 1st, you're welcome to do that. But I'm not going to reschedule it for now. This case needs to move forward. We've had too many delays.
The defendant doubles down, emphasizing the urgency of bank records, firearms verification, and the polygraph. His frustration with prior perjury and insistence on proper evidence creates an intense, almost cinematic tension. You feel the stakes as he argues for his right to prepare fully, while the judge maintains a tight procedural grip. Every word here adds weight to the courtroom battle.
Okay, Your Honor, you should know that before, why I postponed it before, I didn't have the evidence then. I had requested evidence from attorney James R. Watts as far as information from arms list, the phones, the list of firearms, ammunition, and stuff. I had requested stuff like that before and didn't get any response to it. I should have an opportunity to try to destroy probable cause in a proceeding that perjury will be liable.
Okay, you'll have that opportunity October the 1st.
What's that?
You'll have that opportunity October the 1st.
Okay, my parents are lying, and I'm need proceedings to get that under control.
All right. Well, we'll
And
see
I
everybody back October
I also
the 1st.
need to get new glasses. I need to have an eye exam. I filed a motion that might not have gotten to the court yet, but I need to get new glasses, an eye test, and new glasses for court.
Okay. I haven't seen that particular motion, but we'll take it up in due course. So, all right, Miss Pierce, anything further?
No, Your Honor.
Mr. Watts, anything further?
No, sir.
Well, I just want to make sure that I'm going to go ahead and try to get letters off the arms list and net 10 phones and start tracking down the evidence there. And I still want that polygraph taken. I'll be using it for any and everything I can. But I need to make sure that that stuff's in the process, even if it don't.
As we close, the defendant's persistence shines through. He's determined to secure every piece of evidence and ensure his defense is airtight. The suspense lingers as the courtroom scene wraps without resolution, leaving viewers anxious for the next hearing. If you enjoyed this breakdown, don't forget to like the video, subscribe to the channel, and we'll see you in the next video.
Isn't introduced at the preliminary hearing, I still want it.
Yeah, well,
Court filings
that's on
and
you.
reviews of
If you
trial.
wish to obtain that, you have that right. So, all right, if there's nothing further, we'll be in recess. Thank you, everyone.